Can I request you to come onto the podium? Respected sir, Mr. Prasad Subbanna, our speaker for this evening. No. I welcome our Deputy Director, sir. Thank you all for being here. All of you who are taking part in this CME online, well, a warm welcome to you too. Jaldi करनी. I request our director, please, to hand over a potted plant to Mr. Subbanna as a gesture of our gratitude. Sir, over to you. I think everyone's waiting to hear from you.
Good evening. To say that good evening as a warm welcome, considering the humidity in the atmosphere, asking you for a warm welcome would be inappropriate, I suppose. We need much cooler atmosphere than this. Literally, yes. Now, the topic that has been discussed for today's CME is difficulties faced in mediation. Now, kindly see, it is not only the mediators who are the stakeholders here. It can be stratified, and the dichotomy of this you will see. What I have thought of doing is the difficulties faced, one, by the mediators, by the advocates, by the litigants, by the judges, by the staff. Now, all are involved in this process. It is not just the mediator. What commences the process? An opening statement. Now, unless and until an opening statement is effective and powerful, it should be impactful on the persons who are before the mediator. Unless you make the parties and the advocates comprehend the importance of the opening statement, an effective mediation may not happen. It might slip out of your hand. So we have to work within certain confines, whether be it facilitative or evaluative. Now, as we see today in the exponential escalation in the matters that are being referred, particularly in Bengaluru, most of the mediators either are unable to or prevented from giving an effective opening statement. Gone are the days when you see, when we were taught this, maybe 18 years ago, the importance of that opening statement is somewhere down the line getting diluted. With the pressure of work, the advocates would come and say, no, we know everything, you don't have to do it. The parties are clueless about what exactly is happening. When the key factors are missed out about the neutrality of the mediator, the impartiality of the mediator, no bias of the mediator, confidentiality of the process itself, how do you think the parties would try to comprehend what is it that we are doing here? Be it any kind of matter. What is happening in today's fast-paced world? It is more haste and less speed. Everybody wants everything quick. Have no patience to sort of wait and get or reap the benefits. The other thing that comes to mind is the quick negotiation vis-a-vis deliberate negotiation. Everybody wants a quick style. Okay, we have understood, we know this. Now what happens? When it translates to drawing the settlement, that is where the difficulty would arise. One is using vague and ambiguous terminologies in the memorandum of settlement. Who is the ultimate end user, as you can call, is the litigant. Now, either because of pressure of work or the pressure of taking up too many matters to mediate, if we are in a rush to draft the settlement, we will err on the wrong side. So we have to remember that the memorandum of settlement eventually becomes the judgment and decree. So a lot of onus is on the mediator as to how the settlement should be drawn. Simultaneously, you should also have a thorough knowledge of the current developments, the current law, the judgments, the societal fabric, the way people think, what is the mindset of the next generation. We should be equipped with that. See, there was one instance where one of the parties were saying that a particular sum of money should be kept aside for the marriage of the daughter. So, looking at the age of the girl, a hypothetical question I asked, when do you think the girl might get married? I said, maybe in the next 5 years, 10 years. I said, all right, what is the certainty that she will marry? There is no certainty. Then I said, what is the certainty that she will marry a person of the opposite gender? See, this is where we are heading to. See, we cannot shy away from this and say, no, this is a taboo, I will not talk about it. It's a fact. It's a fact which is being projected. You watch any movies or anything on the OTT, everywhere this is projected. So we have to keep up with those times and say, all right, if I lose sight of that, then I may not be able to draft a proper memorandum of settlement. So come out of the fixated ideas of the bygone days. Be in the present and current and understand. Because many a times, luckily we are in this profession where we handle various things. Luckily we are in mediation where we come across various problems. Otherwise, there is no gainsaying the fact that many in our age group would say, ಅಯ್ಯೋ ನಮ್ಮ ಕಾಲದಲ್ಲಿ ಹೇಗಿರ್ತಿತ್ತಪ್ಪ ಅಂದರೆ ಹೌದು ಇರ್ತಿತ್ತು. ನಾನು ದೀಪದ ಕೆಳಗೆ ಓದಿ ಏನೋ ಮಹಾನುಭಾವ ಆದೆ, ಹೌದು, ಹಾಗಾದ್ರೆ ನನ್ನ ಮಗನೂ ದೀಪದ ಕೆಳಗಡೆ ಓದು ಅಲ್ಲ, ಆಗೋದಿಲ್ಲ. ಸಿ, ದಟ್ ಈಸ್ ರಿಯಾಲಿಟಿ. ದಟ್ ಈಸ್ ವಾಟ್ ವಿ ಹ್ಯಾವ್ ಟು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ನೌ let us take one hypothetical example, and see, if a site is allotted to a person, it falls within the, let us say, the lease period with a non-alienation clause. In the event of his demise, how and to whom the property would devolve, what would be the status of the stakeholders claiming the rights over the deceased person's property. Now suppose such a matter is before any one of us. Now we may have to cogitate, how do I write the settlement? Each person will have his or her own ways of trying to tell the mediator that this is what you do. Now we cannot write a settlement because the advocates or the parties think that we should write it in a particular manner. So unless we educate ourselves on what is the law, then only we can draft the settlement, not to please somebody. So that is where we have to be extremely cautious when we have to draft a settlement. Okay. Now this is all, I'll give one more example. That this is food for thought. Many of us who are here have drafted many settlements, but still we come across certain surprises, even today. So we cannot say we know it all. We still have surprises. So if we take another example, of matrimonial matter, where children's education would be taken care of by the father. That would be the sentence. How? Now, merely because the father will take care of the education of the children or child, whatever it might be, when you write a settlement and leave it at that, without and before thinking what will be the future consequential impact of that sentence. The lady might say, okay, did not get on merits, pay the capitation fees. Now if you say, no, I cannot afford it, then they will say, it is in the memorandum of settlement. It's a judgment and decree. Educational expenses to be borne, to what extent? So think. So when we are doing the mediation itself, we should ask, should you keep a cap on it? Let us say up to 5 lakhs the father will pay. Anything over and above that, let somebody else or the mother or whoever. Without a cap, how can you do this? So these are real difficulties which are faced. And especially considering the fact that of docket explosion and the judge's burden. See, yesterday I read that there is one judge per million ratio, which is grossly inadequate considering the kind of population that we have. So what is the burden on that? See, a judge's job when they sit there is an absolutely difficult one. For us, we can argue and walk away. That is why when somebody was asked that, you will be elevated, we want to elevate you, that gentleman said, I would rather utter few nonsense for 5 minutes rather than listen to nonsense for 5 hours. That is the way things are. So, they do not have the time to peruse or scrutinize that settlement word by word. They will depend upon the counsel. Say, ask the parties, have you understood? Are you in agreement? Yes, okay. Let memorandum of settlement be part of the decree. Tomorrow the problem comes. What is the entire aim behind mediation? No appeals and no further litigation. Now, in whose hands it is? In our hands. So, we have to see that how best we can try to incorporate this settlement recorded, covering all aspects. So, we have to anticipate that something may come. We cannot just take it for granted that what we have written will suffice. Because everybody is in a hurry. As I said, haste and speed, there is a difference. More haste, less speed. So, quick negotiation. How do you circumvent these things? This is something which we all should think about, and we have to think about how am I going to do it if when I am sitting there as a mediator. Just because the parties may feel that you are taking more time, or you are not drafting the settlement at the way we want it. So we will have to tell, sorry, that is not how it is done. Now once again what happens, you see, the problem arises more because the volumes are exceptionally high. Now, every day on an average, we will be having 250 plus. What is the infrastructure? What is the availability of the stenographers? So, and many factors. Even the allotment of a matter by the concerned people, how much pressure is there? Now, we all work under that pressure. So, suppose if I have got 5 matters or 6 matters or 10 matters to mediate, how am I going to allocate time to each of the parties? Now, first I should also think of how much can I take. Now, if I take too many things and if I cannot do justice to any one of them also, then there is no point in taking so many matters. We are not doing it for the purpose of statistics, that today I did 10 mediations. Did you do qualitative mediation or quantitative mediation? You ask yourself. If I have done qualitative or quantitative, then answer will tell me what I have done today. So, unless and until we rectify those things, memorandum of settlement is the ultimate thing that we have to concentrate upon. Drawing of settlement itself, we give it as a subject in our training programs, but that is different. When it comes to us, how do we do it? That is where we need to understand, all right, have I covered all the aspects? Now you see, mediation has gone to such great heights, of course, it is common knowledge now that Justice Ravindran gave that in the Lodas case. It was widely publicized. But I would like to share something else which I just saw before coming here. This is in LinkedIn News India. So what it says is, Indian business families are turning to mediation over litigation to settle disputes. Business families are opting for mediation to achieve faster, more private settlements, as Indian court battles are often costly and time consuming. The Lodha brothers and Hindi film director Ramesh Sippy's families are just a few of the examples, the report says. The key benefits of mediation include cost effectiveness, the ability to preserve relationships, and confidentiality on both sides. I mean, just go back in time. When we started this institution, with a few of us, to now, what a metamorphosis it has taken over. Where have we reached? Isn't it? I mean, we are recognized. Everybody wants. They want settlements. But in settling the matter, are we also in a haste to do a quick mediation. See, effective mediation or quick, both we have to bear in mind, because otherwise somewhere there will be, an infusion of wrong settlements, which can have catastrophic effects on the parties. Ultimately, who is the beneficiary of the settlement? The parties. For whose sake are we doing this? For the parties. Whether we call it as service or whether we call it by any other nomenclature. Now the new act has come. What would happen? We don't know. Private mediation may happen. So many things may happen. Whatever it is, at the end of the day, what is your role? It boils down back to that situation where you would say, yes, I have done a proper settlement. It brings us back to, we are all professionals. Who is a professional? A professional is a person who can certify himself without supervision by another person. He is a professional. That is what is required. I cannot call myself a professional if I cannot do it. Nor can I call myself a professional if I cannot answer my own question and say, have I done it? So, what we have learned, what we have been taught, and what we are learning, what we are seeing, it has to be implemented in what we are doing. That is where this entire purpose of amendment of Section 89, the new act, everything would fall into place, without which the benefit will not go. See, how things have changed. We take it in any arena, any field, anywhere, be it medical or engineering or interior designing, anything you take. How much it has changed from what it was to what it is. So when you think of those aspects, an overall comprehension of our own development comes, without which we are limiting ourselves. Let us not self-limit. Let us see to it that we deliver. What is that role of a mediator? So when it comes to that role as a mediator, am I doing a mechanical mediation or getting involved with empathy in the mediation? That is what is required. So you see, in the coming days, this would go even further. And when we talk about trying to reduce the docket explosion, as it is called, the contribution must be of such a nature that it really helps in bringing down that docket explosion. While it brings down the docket explosion, parallelly it should also help the persons who have come before us. Unless and until that is done, it will not happen. So many a times we are faced with certain situations. See, let us now think about, okay, now advocates in their profession, they have their own constraints. Some of them may not have the time to, be present at a particular time. Simultaneously, they would not even allow the parties to go and participate in the mediation. They will say, no, until I come, you cannot. Now that is something, you see, which requires an education or enlightenment of the fraternity. See, what is the point of sending it to mediation? How much time does an advocate spend in discussing about the problem? It is the parties. We call it a party-centric process, but the advocate's interference will come. That is on one hand. They do not come on time. That's another. Now, we have already given time for somebody at 12 and they don't turn up till 3. Now, what do? We are also having our own constraints. And let us remember one thing. We are not growing any younger, isn't it? See, yesterday we were one day older, tomorrow younger, tomorrow will be one day older. The transition from yesterday to tomorrow will not realize until a birthday comes or a new year comes. Now already, 4 months in this year already are getting over. We say, oh my God, 4 months over. It's like that. Time is just going. So what we were 18 years ago when we started to now, there is a constraint. The same level of energies will not be there. We should thank ourselves that we are still doing it. And we'll continue to do it as long as we can. Now think about the problems which also are faced by the staff. How much pressure is there? You know, the file has to come now. The file has to be allotted. The file has to be again retransmitted to the court with the memorandum of settlement. Everybody is putting pressure. Now when so much pressure is being put, how can the staff even take that pressure? If you see in the morning hours at that counter, there is no place even to walk around. It is crowded. It reminds me of, the days when I was in Bombay, where people used to wanted to buy ticket for the first day, first show, and they would all crowd at the counter, and they'll be ready to kill somebody also, or buy in the black market. That is the kind of scenario we find. Hopefully when the new building comes, I think these problems might be addressed. But as on today, that is also a difficulty. When we want to get a settlement drafted, how much time it takes. Now what happens is, there are 3 of them and all 3 are occupied. Everybody is like, how much more time you will take, how much more you will take. If somebody keeps on asking me how much time you will take, how much time you will take, I'll think, okay, let me do a quick job of this. But I am doing a shortcut method, which is unfair to the party. And rightly or wrongly, the knowledge of the Queen's language is very much limited in the people who take the dictation there. So sometimes we have to do too much of grammatical corrections, spelling corrections, that takes more time. So everything adds on to the entire process. So how do we address those issues also? We have to think in what way can we help. So this is something which is like, more of an interactive thing rather than monologue. There should be a dialogue in this, because we should understand, because we are in that field, and we should share our experiences of, okay, when such a situation came, what did I do? How did I do? Now many a times, now of course we are using the VC in many of the matters, so that is helping reduce. See, traveling itself is one arduous task. By the time you reach here, you are already half exhausted. As soon as you come and say, sir, matter. Another problem. So these are day-to-day difficulties. And we cannot, these circumstances beyond our control. Bangalore traffic we cannot control. So we have to accept it. Now it might start raining. We have to accept it. We have no choice in the matter. But when you come here, just take that 5 minutes of pause and then say, okay, now I will start. When we rush, things will not go. Now just imagine, we have spoken about, in our communication skills, negotiation skills, bargaining techniques, impasse, so many things. How much of it is really thought of when we are doing a mediation? Think about it. How much of it is really thought of? We don't. We just start of, okay, what is the problem? What is this? Okay, and go forward and start with the mediation. Getting the background of the parties. How many of us do it? Trying to understand what the real issue is. What is the underlying issue? Who really is concentrating on that? Now we have been told that additional mediators have been taken and empaneled, and they will be starting from 1st of May. Now we should be the guiding light or the torch bearers for them to show the way, unless and until, and they should also be open to sit and try to learn the nuances of the techniques. If that is not done, if I sit on my ego and say, no, I will not, who are you to teach me? I say, I am nobody to teach you. I am not teaching anybody. We are just sharing what we have learned in our experience. That is what we are doing. We are not doing anything else. But unless that open-mindedness is there, that will not come. Have to have an open mind. Many a times, the consultative process of asking somebody may be a junior or a senior, it is immaterial. Because each may be good in certain subjects. What is the harm in asking? If you have to maintain confidentiality, ask it hypothetically. That's all. We don't have to disclose anybody's names or the parties. Ask hypothetically. What would you have done? This is the situation. We'll get some answers. No. Our ego comes in the way and says, no, I cannot ask. I should not ask. So I'm sure you also must have faced these sort of situations, because what we are doing is a practical thing. Mediation is a practical thing. It's not a theory. So when we talk about of communication and how the body language is, many a times I have had to sit representing my clients and I have had to think, is this what was taught? Was there something wrong in the training program? I'm making a very honest, confession here. When I'm sitting there as an advocate representing a party, I don't interfere. It is his or her style. But when I listen to the entire thing or the way it is put, why? It is because you have too much load. There is too much pressure. So it is just, okay, come to the point. Are you settling? Not settling? Okay, what shall I do? Shall I refer it back? If that is what you have to do, take time, no? Even I face the same situation. What do I do then? I tell them very nicely, politely, diplomatically that for today will be opening statement, and understand what is the nature of the difficulty you have, why you have come to court. On the next date, we will spend more time and we will have private sessions also. Most often than not, they all agree, and they will still come at the same time which I tell them. They will participate. So why? The whole point is, it depends on how you put it across. If you tell them, listen, today I don't have time, please come on 25th. If you put it that way, then they'll say, sorry, 25th even I don't have time. You may have time, you can come, I will not come. So we have to learn that aspect. That is what was taught when we did that communications. We should observe the body language of the parties also and see how it is. Some advocates may be like, the cantankerous kind. Okay, fine. How to handle them? We handle what? The process and the people. Both we do. But question is, in reality are we doing? That is the question. Process and the people is fine, but am I doing it? I have to ask myself. So introspection is required. More than anything, all of us need to introspect on this aspect. Am I doing justice to my role as a mediator? Am I drafting a proper drawing of settlement? Does it meet the legal requirement? Will it be accepted by the court? Will there be any consequential problems because of lack of certain things being pointed out? Now that is how I look at it, and that is how I would say we should sort of think about this as a self-improvisation. No age for learning, we can go on improvising. So, though we have difficulties, what do you do if you have a difficulty? It's just like telling, suppose if you don't like a rule, do you break it, bend it, or what do you do? You have the option of questioning it, but until it is set aside or until it is amended or modified, you follow the rules. Now, isn't it? There may be any rule. Motor vehicles also may be there, or any rule or any act. Some things I may not like. Does it mean that I have to ignore that rule? Should I break the rule? So that is where, you see, it will touch upon a larger topic of ethics and integrity also. Okay, for which we do not have the time to. Paucity of time precludes further discussion on that issue. So, at this juncture, I would request our learned friends here to share their thoughts or the difficulties that they think they have faced and how they have either overcome it or what is their suggestion to overcome it. More important, the emphasis is on drawing of settlement, because that is the basic. At the end of the day, that is what it is. Not settled, referred back is, forget it. Drawing of settlement. Let us concentrate on that topic. The field is open. Please feel free to share your thoughts, because my knowledge is shallow. I am not an expert. I am still learning what to do and how to do it. So you have to think of suggesting what you would do, or what are the difficulties that you think you are facing, or you think mediators in general are facing. If you do not want to say as a particular person, please feel free and share your thoughts, so that it will enlighten all of us who are sitting here. ಇಲ್ಲಿ ಅದು ಯಾರು ಹ್ಯಾಂಡ್ ಮೈಕ್ ಯಾರಿಗಾದ್ರು ಬೇಕಾದ್ರೆ ಕೊಡಿ.
Thank you for the inputs, Brother Subana. I think while drawing the agreement, one has to take the inputs from both the parties. Sometimes there will be a lot of confusion and legal intervention, but we have to follow whatever is lawful and what is the subject matter about, and not leave the ambiguities. As you rightly said, the objective of mediation is to put an end to everything. It should be more comprehensive, and even if you take time, you need not rush up. If suppose I am busy with other work, I will just have it postponed or give a date and take up the inputs. I request both the advocates to come out with some draft agreement, so that we can sit down on the next day and discuss about that, and entirely then if both parties are agreeable, then only we go ahead. I don't rush up in drafting the agreement, because it is ultimately the voluntary process of the, I don't rush with the process. Thank you, brother.
True.
I agree with Mr. Bharat Mehta and Mr. Prasad Subana. I think what Prasad is saying is quantity is controlling quality. Because of the quantity of mediation, our quality of mediation is getting probably deteriorated. That should not happen. We are all professionals. We are expected to maintain equality. As lawyers, we have the same challenge. As a family man, we have the same challenge. Everywhere whatever we do, there is quantity coming in the way of the quality. We have seen recently also one of the pilot who had to do certain extra trips had to succumb to pressure and die because of the number of hours he had to put in. I mean, the flying hours had increased without his knowledge, and he had difficulty. So he can't say, sorry, I did not drive well today because I was overworked. So similarly, I think we should also, within the time available, maybe this is one trick which we can do, take a long, deep breath, able to think on your shoes where you are, as he put it and as he put it, introspect within that short 1 minute or 1 second, get into the role, don't blame the system, because the whole system is like that. We also do the same thing when we do it to others. So try to do introspect. For your experience, for your life experience, for your mediation experience, you should be able to immediately get to the quality and do the work which is required to be done. We can't execute it unless we are there in the situation. So I think self-introspection could be through taking 2 deep breaths. You'll be into the role and you'll do that. This is what I feel. This is one of the practical tips, probably it may help you.
If others are having, anybody else has anything to share?
In a suit for declaration, a minus property was sold. Minus property. A minus minor's property was sold under registered sale deed. Minor's property was sold under registered sale deed. The purchaser had approached a bank for availing financial assistance. The bank had raised a question that the court had not permitted the sale, and therefore they could not give any credit facility to the person who had approached them. Therefore, they had filed a suit for declaration. The purchaser had filed a suit for declaration that the sale was for the benefit of the child, minor child. The matter was referred to mediation. Incidentally, matter was referred to me. And both the parties, even before I commenced my opening statement, they said we have already settled. We'll just draft the, kindly draft the agreement and send it, we'll close it. I had an opening statement. Thereafter, I collected the statement of facts, and I found that such a agreement cannot be drafted in the Mediation Centre because under the Minors and the Guardians and Minority Act, it's for the court to determine whether the sale is for the welfare of the child or not. Therefore, I politely said, this is the situation, we cannot draw any agreement even if the parties are willing. So I politely took them to the director or deputy director, and it was explained to them that it was for the court to determine as to whether the sale is for the welfare of the child or not. And even all the parties to the mediation were agreeable. Such an agreement cannot be drafted in the Mediation Centre, and the matter was sent back to the court. Sir.
No, that is the right approach. Because you see, what about the minor's right?
Correct.
What would happen when the minor becomes a major? See, that is where, you see, our rule says, with 15 years experience, because we would have learned something in that about the law. But luckily for you, okay, you understood the situation. Now we should assume that somebody, see, we do facilitative mediation, we do evaluative mediation, we do commercial mediations also, we do non-commercial family mediations also. We cannot call ourselves experts in all the fields. Now suppose a matter comes in which I am not good in that subject of law. Either I should opt for co-mediation or I should consult our director or deputy director. Many a times, even now you can ask them, I have gone to them, our deputy director, I have gone to them many a times and I have shown provision of law is this, they have mentioned, how can this be mediated? Then he has guided, he has told, either you ask them to get it amended and bring it, or you would say it's not fit for mediation. See, there is nothing wrong in our going and asking, because see, where will that settlement end up? Today they are on OOD, tomorrow they will be sitting on the bench, it will come before them and they will say, what is this? Isn't it? So, what you have done was the right thing, and only point is, how do we put it to the parties? Because they are settled. Now they say, when we have settled, who are you to come in the way? We are not coming in the way, the law is coming in the way. I'll tell you one more example for this. When I talk about the law in this thing, there was a person who had two wives. Okay, that matter was referred, and one wife was in Hubli and one wife was in Bangalore. Both did not know the existence of the two. So yeah, so he was having a nice time and jolly life. So somehow the second wife came to know about the existence of the first wife. So she came and filed for divorce. Now that matter when came for mediation, I still appreciate his naivety and sort of his own innocence. He was not coming from that literate background. So he asked me in Kannada, "Sir, hinde Raja Maharajarge ಎಷ್ಟು ಜನ ಇರ್ತಾ ಇದ್ರು ಸರ್? ನಾನು ಏನು ತಪ್ಪು ಮಾಡಿದೆ? ಎರಡು. ಈಗ ಇಂಥವ್ರಿಗೆ ಏನು ಉತ್ತರ ಕೊಡ್ತೀರಿ?" ನಾನು ಹೇಳಿದೆ, ಆಯ್ತಪ್ಪ, ಒಂದು ಕೆಲಸ ಮಾಡಿಬಿಡಿ, ನೀವು ಯಾವೂರಿನ ರಾಜ ಮಹಾರಾಜ ಅಂತ ಹೇಳಿಬಿಡಿ, ನಾನು ಬರೆದು ಬಿಡ್ತೀನಿ. ದೆನ್ ಅಫ್ಕೋರ್ಸ್ ಹ್ಯಾಡ್ ಟು ಎಕ್ಸ್ಪ್ಲೇನ್ ವಾಟ್ ಇಸ್ ದ ಲಾ. ದೆನ್ ಆಮೇಲೆ ಏನೋ 2 ಲಕ್ಷ ಕೊಟ್ಟು ಸಾಲ್ವ್ ಮಾಡ್ಕೊಂಡ, ದಟ್ ಇಸ್ ಡಿಫರೆಂಟ್. ಬಟ್ ಸಪೋಸ್ ವಿ ಫರ್ಗೆಟ್ ದಟ್. ಕೆಲವು ಕಡೆ ಅದು ಆಗಿದೆ, ವೇರ್ ದೇ ಹ್ಯಾವ್ ಸೆಡ್ ನೋ, ಸಪೋಸ್ ಇದು ಎಲ್ಲಿ ಬಂದಿದೆ ಅಂದರೆ, ವೆನ್ ದ ಫಸ್ಟ್ ವೈಫ್ ಈಸ್ ಅನೇಬಲ್ ಟು ಬೇರ್ ಚಿಲ್ಡ್ರನ್ ಆರ್ ಚೈಲ್ಡ್, ನನ್ನ ತಂಗಿನೋ ಯಾರೋ ಮದುವೆ ಮಾಡ್ಕೋಬೋದು, ನನ್ನ ಒಪ್ಪಿಗೆ ಇದೆ. ನೋ, ಕ್ಯಾನ್ ವಿ ರೈಟ್ ದಟ್ ಸೆಟಲ್ಮೆಂಟ್? ಅವ್ರಿಗೆ ಅದು ಕಷ್ಟ ಇಲ್ಲ, ನನಗೇನೆ ಕಷ್ಟ ಅಂತ. ಸೊ ವಿ ಹ್ಯಾವ್ ಟು ಥಿಂಕ್ ಅಲ್ಟಿಮೇಟ್ಲಿ ವಾಟ್ ದೇ ವಿಲ್ ಡೂ, isn't it? So we really need to think. And suppose best is, anta situation bandre, take time maybe. Suppose we can't have a ready answer, take some time. Best. Anyway, we have 60 days alla, yak tagobardu. Somebody else would like to.
Court annexed mediation and not a private mediation. In that, of course, it ended in a non-settlement. I would not call it a failure because subsequently there was another mediation and it ended in a settlement. But before that, the husband was in Australia. So we did a VC. And for that, by the end of 2-3 sessions, when it was moving towards a non-settlement, he asked for husband's rights. What are the husband's rights of the husband? You mediators should know about it and please give it to me in writing about the rights of the husband. And not only that, he said, can you, because I am in Australia, can you give me a summarized statement from day 1 of the mediation till day 5 or day 6, the terms of, not the terms exactly, what transpired here, because I would want to know and I want a statement saying that what all transpired here is this and nothing more. Should I have given that? I did not give it. I said we don't make notes. Everything in mediation is confidential and you can get the husband's rights and everything in some of the Supreme Court judgments, which you can look at it. I cannot, you can ask your advocate to give you an advice on it. I cannot give all this, is what I declined.
Correct. Absolutely. I mean, how can we even share whatever notes we take, or how can we even make a suggestion as to what are the rights? If he does not have a counsel of his own, he can appoint a counsel and take guidance. So you see, these are also some of the difficulties. See, suddenly nowadays what is happening, I'll tell you another practical difficulty that is cropping up. When we give the draft, they suddenly start taking photos. Before we realize, they are so quick. I was sorry, this is not permitted. I mean, see, nowadays the other fear that is creeping in is, how do we know they are recording or not recording? You can just keep a phone here and keep it. I don't know. I mean, it is becoming so scary nowadays. Even, to entertain sometimes clients in the office, we start thinking, should we tell them you keep your phone outside and come? I mean, too many changes, and some of them are really, impactful on our profession. See, I may give an advice. He may hold me to it and say, you gave the advice. So I'm so cautious even in sending a message on WhatsApp. I don't send. You can call me, that's all. 1 word, 2 words. See, so many things which is continuously happening, and that is when I said in the beginning that if we don't keep up with the changes and stagnate at where we were, then the difficulty comes. I think Madam Brinda wanted to ask something or tell something.
Good evening. That was a wonderful presentation because as mediators we do face a lot of challenges. One thing is when times we are very happy the matter is settled, but at the time of drafting the settlement, the lawyers raise a lot of objections. Sir, as you all know, you have all taught us that the settlement should be party friendly. The wording should be very simple, but sometimes there will be objections from the lawyers. So it's not a question, it's just saying, I'm sharing my experiences. So it requires another round of negotiations with the lawyers, whether a clause should be there or a word should be there. Like for example, a simple thing like if the installments are not paid, the party is entitled to file an execution proceeding to recover the amount. Once one lawyer objected to it, he said, don't put it, it's understood. It's understood by the lawyer, but not by the parties. So this is some of the problems we do
Yes,
face.
yes, yes.
So thank you, sir. That's just wonderful.
No. See, that is what you raised is a very interesting thing because kindly be seated. Because you see what is happening. What the lawyers would have promised outside, we don't know here. Now you see, talking of that, though we tell in the opening statement that this is a free service and we are doing voluntary, etc., etc. What has transpired outside, we don't know. I mean, it is like, I heard it from some people saying that, no, we will have this mediator and, he will do a very good, right? However much or however many times you might tell that, look here, it is voluntary, we are giving our time and coming here. What has happened outside, we don't know. And let us say the matter gets resolved. Then they will take credit for that also, saying that, see, I told you, no, he's a good mediator, so I had already sort of told him. See, now, with the number of lawyers that we have in Bangalore, I think must be more than 4 lakh, I think, it is becoming very difficult. And suddenly we find that there are too many of them mushrooming in all kinds of courts. I see so many new faces even in the family court. And many of them have not practiced on the family law at all. Many a time they just file wakalat without section 13 application and the judge has to say, section 13 akri. I mean, to that extent. So what is happening now is like everybody is only after one thing, that as soon as I pass out, next day after enrollment, I should have a car, I should have a house, I should have this. So you are just running after an oasis. It is like that. We struggled hard and came up, but they just want quick results. So where to get the quick results? Promise the client, I will get it done. If I don't toe the line, then they'll say, no, we want change of mediator. That's the next thing. No, you are not ready for this. Suppose I say, think about it and come back. Oh, you are not, change the mediator. Then preferential mediators, that is another thing that is happening. No, we want only this. So luckily our deputy director knows more about the advocates who come and he would cut them there only. So that is our saving grace. Otherwise so much pressure. They will come and ask, free idira? Allot ಮಾಡಿಸ್ಕೊಂಬಿಡೋಣ ನಾನು ಹೇಳಬೇಡಿ ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿದ ಯಾರೆಲ್ಲ allot ಮಾಡೋದು. What to do? Because I don't know what has happened outside. That is my worry. Major worry is that. So you see, it is not just one thing. That also we have to think of. When I talk about difficulty, I have to think of that difficulty also. Or they try to, like pressurize you. When the courts are ready, when the judgment are there, they'll start trying to quote. Supreme Court has said, that has said, this has said. Okay, many things have said. Okay. But is it relatable to this case? And we are not going by that. We are going by the tailor-made drafting for your clients. We are not writing the judgment there, saying that the Honorable Supreme Court has held, so I write this memorandum of settlement. Isn't it? So somebody else would like to enlighten us. Mr. Humayun wants to enlighten us. Of course, you are a very senior member, you can certainly do it. Yes, Mr. Humayun, anything you have, or Mr. Biju, or
Sir, this is a common problem which keeps coming, especially in the second half, after 3 o'clock, when the rush is too much. Advocates, clients all keep piling up. We have some few files already in hand, few clients to attend. That time some advocate, along with the parties, matter has been allotted. So they come rushing to the room asking that, this matter is already settled. We only want to draw the agreement. If the agreement happens today, we are okay to take the agreement, otherwise send the file back. So we get confused whether to attend the rest of the clients or go ahead with this agreement or what to do. They disturb the rest of the matters also. So in such situations, what is the right method to be adopted?
That's a very interesting question, and it's a very practical question. Mr. Biju, what I would say is, please be seated. What I would say is, let us not be get browbeaten by anybody. Okay? We go at our pace. Now, if you are in a mortal urgency to get it done, and if you think there is somebody else or something else you can get it done, you are most welcome to do it. See, first of all, we are spending our time, effort, energy coming here and doing it. Now, you cannot just walk in and say everything is settled and you just draft it. It's like, an analogous situation would be comparing to a postman. A postman would deliver a letter irrespective of the contents, whether it is good news or bad news. He will just go and deliver. We are not postmen here that you bring the settlement and I'll just sign form number 3. We are not doing that. You have to wait your turn. If you are in a hurry, okay, come tomorrow. You can see the rush, you can see the number of cases. So, no, on this, I think we may need to deliberate along with our director and deputy director and sit and discuss about how to manage the time and case flow management. How to manage that. Now, suppose, this is just my thoughts, I don't know how it will be considered. We get so much of inflow. Suppose on the first day at the threshold we tell them that, see, today there are so many matters, so many mediators are there, your turn to come may take some time. So, we will allot you this date, you please come on that date at this time. I don't know, perhaps something has to be done. And as you rightly said, after 3 o'clock it is chaotic. Some such methodology we have to think of, and let us all think about it and give our own suggestions to the board and the director and the deputy director. Let them think in their wisdom what is best. But one thing, come what may, under pressure we will not do it. That is given. We will not succumb to that tactics. That is impossible. Because we are diluting the entire process then. Tomorrow they will come with a written settlement, put it on a pen drive, give it there in the typing pool, take a print out and say sign this. Why not? Shall we encourage that? No, that is not possible. That is not possible. You tell them politely, I'm sorry, I already have so many matters. Your turn will come, I'll call you. If patience is not their virtue, we cannot help it. Let them have patience, isn't it? If it goes back to court, how many months, years or thing it will take? What is the harm in waiting for 1 day or 1 week? Nothing, isn't it? So, anybody else? Before.
Sir, one more doubt.
Sorry.
Sir, normally, Jaykirti has asked one question, I continue with that. Sometimes a nullity petition has been referred.
Correct.
We know that we need to do the trial and all that. But then since the referral judge refers it thinking that if there is a settlement, if there is a reunion, let them try it. And that is how the matter has been assigned to us. We do the opening statement, hear them out and they talk in details. And end of the day we say that we are not in a position to draw the agreement and it will have to be send it back to the court. Likewise, we will have P&SC matters. There might be declaration matters asking us to declare certain things. All that is not possible, we also know. Sometimes, partition in certain religion which is not possible. All those petitions come to us which has been referred. Of course, as per the rule, we go with the opening statement, whether it is allowed or not, we go with the opening statement. But then how to put it to the party that this is not possible as per the rule, as per the law? Or are we supposed to hear them out, draw an agreement and send it to the referral judge, or let the referral judge take a call whether it is binding or whether it is within the purview of law or not? Or straight away, as you rightly said, go to the director and tell this doesn't come, we cannot mediate this matter and send the file straight back to the court. does the referral judge takes the onus, or we have an authority, because since it is an unlearning process and all that, our job is to only facilitate. So you just go ahead and sit and listen to the party and then take a call, whether which one we should adopt.
Yes. See, it opens too many things to discuss on this particular question. But to put it pithily, see, it is not the mediating section 12 is not a bar actually. You can mediate, okay? But we cannot give a certificate of nullity if it comes to that. In the mediation, what might transpire, that is different aspect. To that extent, we can accommodate, all right? But there are certain types of matters which, if you feel, you know, how to put it across to the parties, depends upon the background of the parties, literate, semi-literate, illiterate, you know, educated or only qualified, because there are more people who are qualified and less educated. So that differentiation we have to bear in mind. Or should we take the advocates into confidence and tell that, sorry, this is the matter, could you tell your clients? See, many a times because of copy paste, wrong provision of law is applied and it has come. So instead of making the lawyer lose his face before the client, I have called the lawyer separately and told him, sir, there is a problem here which I don't want to discuss in front of your clients. So he has been very, you know, sort of obligated and said, thank you very much, but copy paste. I said, we cannot amend it, so take it back. So once again, as I said, it depends on how you put it. How you put it across. That is the way only in which we can, you know, win over the people. We can do it. I mean, in some it is inherent, perhaps some inculcate, some imbibe, some may imitate. We don't know. Ms. Jayashree wanted to say something.
I would request the Harvard bench if they want to add on anything.
Draft of the settlement to by online to the either the advocate or their clients, mainly probably to the advocates. So what is the harm in allowing them to take photograph of the settlement, is what they are asking.
See, our rules do not permit them because, simple, it is a memorandum of settlement. It is not yet a judgment, isn't it? When does it become a judgment? When the judge signs it, it becomes a judgment. So judgment you getting online is different, or it is uploaded on the system, that is different. Nowadays it is uploaded straight on the system. You don't even have to wait for a certified copy. We can just read the judgment. Memorandum of settlements are not uploaded, no? So how can we allow them to take photos? What if they go back, think and come again and say, no, I am not interested in this? We should not give room for that one. Sorry? No, the memorandum of settlement is put online. No. Correct. That part, yes. When we are doing, yes. That part is correct. When we are doing online, we scan it, we send it, they sign the scan, send it back to the other party, and then it happens. Then they will appear before VC. But the ratio of that, vis-a-vis the ratio of this is far different. That is one thing. And another thing, Mr. Biju, what he asked is about, the referral judges sending the matters. So on that question, I'll say only thing, the judges are under so much pressure that they do not have the time to go through each and every pleading, prayer, provision of law and then refer. Both parties present, okay. Nowadays, even the request of the advocates, it is being referred. That both advocates present, counsel request for mediation, refer the matter to mediation. So we cannot expect the judges to read and then refer. It's humanly impossible, especially in places like Bangalore. Yes, Mrs. Jayashree, you want to?
I would request the Harvard bench if they have any queries, if they have anything to share. Kalburgi bench and Harvard bench, they are there. Huh? No, I think.
Can't hear. Somebody is there? Idara? Idara? They have questions. Somebody is.
Mute ಆಗಿದೆ ಅನ್ಸುತ್ತೆ.
Sorry?
They are muted, I believe. It's not working. Okay. So,
Hello, Madam Chandrakala. Do you have any doubt, ma'am? Please unmute your mic. Ma'am, do you have any queries? We can't hear you, ma'am.
Can you hear? Are they asking or any question? You can't make it. ಅವ್ರೇನಾದ್ರು ಕೇಳ್ತಾ ಇದ್ರೆ ನಮಗೆ ಕೇಳಿಸ್ತಾ ಇಲ್ವಲ್ಲ, ಏನಾದ್ರು ಕ್ವೆಶ್ಚನ್ ಇದೆಯಾ ಅನ್ನೋದು ಇಲ್ಲಿ ಕೇಳಿಸ್ತಾನೂ ಇಲ್ಲ, ಕಾಣಿಸ್ತಾನೂ ಇಲ್ಲ.
Dharwad bench, please come in.
ಹೌದು, ಅಲ್ಲಿಂದ
Dharwad bench.
ಚಂದ್ರಕಲಾ.
So, on behalf of Karnataka Mediation Centre, I extend my sincere thanks to our speaker, Shri Prasad Subarna, for sharing valuable insights on the importance of settlement agreement in mediation, challenges faced by the mediator, and how it can be overcome by having thorough knowledge about the law and practices. Thank you, sir. Thank you very much. So I thank our Honorable Board of Governors, Registrar General, High Court of Karnataka, Registrars, High Court of Karnataka, Dharwad and Kalburgi branch, Honorable Director, Karnataka Mediation Centre, Shri Gopalappa, Honorable Deputy Director, Shri S.S. Bharat, all mediators for actively engaging and making it an interactive session, the technical staff and staff of Karnataka Mediation Centre. Thank you one and all for this.